It's 1 o'clock, and I think we're ready to start. I welcome everybody to the 61st meeting of the Massachusetts Gaming Commission. The chairman is not with us today. He's in Washington, D.C. for a fascinating ceremony at the Air and Space Museum, in which they're opening a new exhibit dealing with air navigation, featuring his father, who was a navigator during the Second World War. And so the exhibition, which is a permanent exhibition in the Smithsonian, will open today and will continue permanently. That's what a permanent exhibit does. And so he is there participating in the ceremony. So we are going to proceed in his absence, but we're with him in spirit. The first item of business is approval of the minutes of March 12. We have no minutes of March 12. Next week, we will have a minute tsunami. We're a little backed up in the minutes for a variety of reasons, resulting from the many hearings we had a week or so ago. But we'll try and get all of that straightened out next week, and thus I anticipate a number of minutes to be presented for approval. The second item on the agenda, and we're going to deal with this without displaying the schedule today, is administration and a discussion of the master schedule. Commissioner Zuniga.
Thank you, Mr. Chairman, in absence of the chairman. I don't have a big update on the schedule. We continue to contemplate the three scenarios that we have discussed a few weeks ago, and I'm preparing the tool to let us really analyze those scenarios, hopefully in the next meeting of the Commission a week from today. So the schedule and all its dates remain the same as of now. And the update is that we should have a discussion about all those details in the upcoming meeting a week from today.
So the plan is, the scenarios, Commissioner, that you're referring to are the scenarios for scheduling the slots, parlor processing, and license issuing.
Correct. Yeah. Correct. There is. We currently have a determination of suitability of the slots parlors applicants for late April 30th. We are contemplating, and this is subject to how these investigations progress, right, as to whether and how likely it could be that those investigations be done sooner. That's a question for the IEB and all the open questions there relative to all the qualifiers. Anyway, that's really the extent of that.
We'll hold next week. We'll have a full.
Yeah, the three scenarios really involve the determination of the schedule relative to Category 2, or the slots parlor license.
The idea is to try next week to see if we can zero in on one of those scenarios, if we can, and then set a schedule that we will be able to, with reasonable confidence, adhere to and predict the outcome.
Correct.
Yeah. Good.
Correct.
Good. All right. Any comments or thoughts, questions about that?
Hold till next week.
Right. The qualifier status review, Director, General Counsel Blue.
Good afternoon.
Good afternoon. Good afternoon.
I am here before you today to bring to you a request for a vote on a qualifier. By way of background, as the Commission is aware, if a person or entity has a significant interest in an applicant, they must submit to the Commission's qualification process. If they refuse to submit to that process, then they would need to divest themselves of that interest. Vernado has an interest in the Sterling Suffolk application. They declined to participate in the qualification process. We advised them that then they would need to divest. In order to do that, however, it'll take more time than our process has built in. So we have looked at other jurisdictions to determine if there is a way to address that. And one other jurisdiction has advised us that a way to do that would be to place that interest into a blind trust. with an independent trustee who would then become the qualifier and submit to our qualification process. Any transfer out of that trust would be subject to the Commission's transfer regulations, and that person would also have to qualify. So what I have before you today is a request to approve Bernardo's placing their interest into a trust with an independent trustee. We submitted a copy of his bio. He's from the firm of Hemingway and Barnes. And with the knowledge that Bernardo will have no influence or impact on that interest while it is in the trust, the trustee will be the qualifier, and when that interest is divested, the person that it is divested to will submit to the qualification process. I would also ask that you approve, once the trust is in place, that the qualifiers withdraw. The Bernardo qualifiers be allowed to withdraw, and that the Sterling Suffolk application be allowed to proceed.
All right. Discussion, thoughts, questions, comments?
Catherine, the memo reflects the parties have proposed. Are we included in making that recommendation as to who the trustee was?
Not in terms of who the trustee is, although we have reviewed who the trustee is, and we
Okay.
believe they're an independent person.
Okay.
Is there a timeline or a projection for this divestiture?
They would like to do it as soon as possible. Definitely once, they would prefer to do it, I believe, if they could do it before the trust went into effect. I don't think there'll be time to do that, so it would be as soon as possible as they can do it.
I'm aware that this was used in New Jersey, a very similar type of situation, and I know that it's worked effectively there. The process, the trustee did qualify and continues to qualify, and I know that it's worked without issue in New Jersey, so.
The essence of this, as I understand it, and so that everybody watching and looking can understand it, is that the interest owned by Vornado is now, if this proceeds, in this trust, and Vornado won't have any control over that interest.
That's correct.
The control will be exclusively in the hands of the trustee.
Yes.
The trustee will go through our customary qualification process. We're not voting on the trustee today.
That's correct.
He will have to go through the qualification process. And then when the trustee transfers the Vornado interest to another person or entity, that person or entity, before they can assume control and move forward with the application, will have to go through the qualifier process, just like everybody else.
That's right. We have asked that the trust document include language that says that any transferee will have to go through the same process that all of our qualifiers do.
Okay. So this is really just a bridge to allow Vornado to divest itself of its interest in the project and allow the process to move forward while that divestiture is taking place.
That's right.
And I know Director Wells isn't here, but is it correct that we don't believe this will delay any kind of our determination of suitability as we have it contemplated in our current schedule? Is that a full statement?
I did discuss that with Director Wells, and she does not believe that it'll add time to it. We should be able to proceed along our regular schedule.
So the vote, Ms. Blue, that you're seeking today is a vote to approve the use of a trust, a blind trust, to allow, the terms of which you have reviewed, to allow Vornado to divest itself of its interest in the Sterling Suffolk proposal, and to require the trustee to proceed through the same qualification process as all other qualifiers are required to undergo.
Yes, and in addition to that, to allow the Vornado entities to withdraw once the trust is set in place.
All right. Any further questions, comments, concerns? So let's put that in the form of a motion, and at the risk of repeating and making a mistake in the process of doing so, I would move that the commission approve placement of the interest of the Vornado entities in the Sterling Suffolk Racecourse proposal in a blind trust over which they have no control, and requiring the trustee of that trust to qualify through the commission's normal qualification process. And upon the trustee's qualification,
Yes.
permit the Vornado qualifiers to withdraw.
Yes, that is correct.
All right.
Second.
All in favor?
Aye.
All right.
Thank you.
Thank you.
Thank you very much. All right, the next item on the agenda is public education and information. Ombudsman Ziemba.
Thank you, Commissioner. As you just noted, today we were tentatively thinking about having more of an update regarding the Category 2 licensing schedule. I think that we're still in the process of collecting all the information that would be needed for a full discussion of that matter for next week. Within that context, I just wanted to note we continue to have many conversations with host and surrounding communities, and when we discuss the timetables, and I know the Commission is said that this is a big concern in setting timetables, that we should take into account the ability of both host and surrounding communities to understand the impacts that may occur within their borders, and so that when we set our timetables, that appropriate time has to be given. Pardon me. Appropriate time has to be given to enable them to understand those impacts. So that will be part of our analysis for next week as well. This week we have a deadline for applicants responding to us on whether or not they are interested in utilizing the RPA planning process that we discussed in recent weeks. I report that we haven't received all of the responses just yet, but overwhelmingly applicants have noted to us that they are very interested in having a scoping or planning session with the regional planning agencies, and it's been sort of a split response on whether or not they commit now to utilizing the RPAs or whether or not they want to wait to have those conversations on that scoping or planning session. I'm not aware that we have received a formal response saying that they're not interested just yet, but I think there may be at least one that might not be interested. And then finally, I report that we've had conversations with the Central Mass Regional Planning Commission. As we noted in the past, that is the one area due to the recent Category 2 applicant for Worcester, that additional services beyond the RPAs that we had previously identified would be needed, and those conversations are ongoing, and it looks like we'll have a very fruitful dialogue with them on utilizing them in the future. We've had very, very positive discussions with them. That's what I have to report.
Any questions for Ombudsman Ziemba? No, that's very helpful, and we will talk next week about the considerations that go into setting the whatever timelines we think are appropriate and how those affect the surrounding community. So there'll be a clear discussion of that.
That's great.
Right. Great.
Thank you.
Good.
Thank you.
Thank you. All right, that brings us to the regulation update. Mr. Grossman, or? All right, good afternoon. So this is a sequel to the meeting that we had on Monday when we considered the draft regulations to get them ready for today's vote, really, to start the formal promulgation process. So with that as a brief backdrop, go ahead.
Thank you. What we've done is we've incorporated, or attempted to incorporate anyway, all of the comments that were made on Monday by the commissioners, as well as made a few further adjustments after taking one further read through the regulations in their entirety, and we've incorporated all those changes. There are just a couple of new areas that I'll just quickly point out, and then if there are any other areas that you'd like to discuss, we can certainly do that. On page 4 of the update to the existing regulations, so that's 102 through 117, we added in a provision relative to legal challenges. And suggest that no person or local government entity may challenge or seek to enjoin commission action based on a claim that an applicant and/or the commission has not complied with the regulations. And what that means is, in distinction from saying, as we had before, that you can't appeal. Here, we're saying that no act or failure to act may be challenged. What we had said before that we determined was not something that we should do was that you couldn't challenge a decision that was made. This is different. This is a procedural prohibition, and that's why that was in there. That's where that came from. And we think this is, from a legal perspective, something that will pass muster where we had concerns about the other provision. So that's where that stems from.
Is it a replacement or the other provision is elsewhere?
The other provision we took out.
Okay.
There was some question as to whether that would pass legal scrutiny. So we took it out. It may not, but that was removed. This is not intended to replace it. This addresses a different issue, although it may look similar. This talks about the process. So if you choose not to do something for a particular application, that's what we're talking about. We're not talking about the final decision.
The other, the former one was outcome. Nobody could challenge an outcome, no matter how it was reached.
Right.
And this talks about people not being able to challenge the process or parts of the process by which we reach the outcome. Is that a fair?
That's exactly right.
Yeah.
The second area I would draw your attention to is on page 6. These are just amendments that deal with the confidentiality of the RFA2 applications. And you'll see essentially all we've done is expanded the process that's presently in place to include the RFA2 applications, though we certainly have had some difficulty with the process. In the first instance, I don't think it has anything to do with the rules. I think the rules are fairly clear. So that's why I think this is a workable proposal.
Let me just take a minute to say something about that, not because it deals with the regulations, but because there are continuing concerns expressed about the processing of the applications. I remind ourselves and all who are interested that what we're dealing with is 21,000 pages of personal information. And that personal information, in some cases, is not self-evident. And so some of the applicants have asked for additional information that on its face doesn't look like it's personal information to be kept from disclosure because, in fact, when you examine the facts surrounding the information bit, it is personal information. It's just hard to tell. Things like divorce records and the like. We are trying very hard to process these quickly and, in fact, have released the names of all 300 qualifiers, and they are available for everybody to look at. The Phase 1 applications that we're working on now do not contain any site-specific information. By looking at the application, you can't tell where the qualifier is going to want to put a place. We are making every effort to get through this process as quickly as we can. But the plain fact of the matter is that under the general laws, we are not permitted to release information that is exempt from disclosure for privacy reasons. And therefore, it's not simply a matter of discretion. We have to be careful to go through these records and take a look at the information that is exempt from disclosure as a public record because another statute, not the public records statute properly, prohibits us from disclosing that information. So it's not simply a matter of quickly taking our best guess and then letting fly with what we come up with. We have to be very careful with this, and we are doing our very best to do so consistent with our statutory obligations and with the public's undoubted right to know the information that the Public Records Act makes available to them. So I know the frustration exists in some quarters as to the speed with which we're proceeding, and that's the basis for what we're doing and how we're trying to do it. That's off the track a little bit, but since this section of the reg deals with that, I thought it was an opportune time to reiterate what we've said at a number of different occasions in a number of different forms once more.
Commissioner, in the same spirit of that thought process, is it fair to say that we're anticipating the Phase 2 form to contain, just like it did for Phase 1, to contain the specific areas of redaction where we may assume that there's personal or confidential information to serve as a guide, or is this Phase 2 fundamentally different in other ways?
No, and much more of the Phase 2 application, which concerns the site and characteristics of the site and the like, much more of that, percentage-wise, is going to be in the public domain without question. And the form, I think, we can design in a way that isolates the stuff that presumptively is exempt from disclosure because it's a trade secret, or there won't be much personal privacy there, I think, but a trade secret or other things that the statute itself exempts from disclosure. I think we can isolate those so that we can more quickly and indicate in a specimen form that it's exempt. Part of the problem here is that we don't have a way to isolate this data. There is some public information and some private information on almost every one of these 21,000 pages. So you can't just go to a section of the application and say this section presumptively is not public and this section presumptively is. You've got to look at every single page almost and pick out those things that are public and pick out those things that are not. There was, in fact, no other way to organize this part of it in a meaningful sense, in a way that allowed it to be processed meaningfully. So that adds to the difficulty of trying to process these things, and we can and will do it differently in the next phase because the next phase is inherently different from this one. So hopefully we won't run into these same problems.
So all this draft does essentially is extends the regs to the RFA2 process, and it basically says that we will have a specimen form that should be submitted along with the unredacted form, and that applicants may submit separate requests for confidential treatment of certain portions of the application, just like with this process. So that's what that section does.
Sorry for that long interruption.
No, thank you. I think it's helpful to clarify that point. Because it highlights that the problem is not with the regulations, I don't think.
Right.
So that's why we didn't set out to completely restructure the regulation.
Right.
The next comments I'd just like to make pertain to the other document that deal with sections 118 through 131. And the first comment is on page 15. There were two areas I just quickly, well, maybe not quickly, but I did want to draw your attention to. The first, you'll see in red, language was added to clarify the evaluation. I thought it was important that you take a look at that. I think that was the commission's intention.
See subsection C? of
It's
number
two. It's 119.03, part 2,
Okay.
in red.
Are you comfortable with that, Commissioner? You are, okay. All right.
Okay. And my only other comment was, as you can see, highlighted in subsection C of Part 2, we added in the architectural access regulations. I thought it would be important to clarify that, and that making these buildings fully accessible is an important element of the design as well. And though that is, in some respects, subsumed within the building code itself, oftentimes it's helpful to separately highlight accessibility compliance. My next comment was just on page 29.
Can I just one? Sorry, never mind. Please continue.
On page 29, I just filled in one of the blanks that was missing from our last go-around, and just to clarify what that is, under the Office of Campaign and Political Finance regulations, it was suggested that when the applicant reimburses the municipality, the host community, for the cost of the election, that the information as to that reimbursement itself will likely have to be disclosed. So that's what that regulation is that's been highlighted there.
The 970 CMR down near the bottom?
Yes, that's a
Okay.
contribution section.
Okay.
And then finally, on page 53, we added in, as requested, a section dealing with the arbitration to determine if necessary, to determine the fair market value of a gaming establishment upon the transfer of a license. And it largely is reflective of the other arbitration provisions in the draft regulations, though certainly it has some slightly different nuances.
All right. We still, in connection with those transfers, there are no changes to 129.01H or K. We still have to explore, how we're going to deal with those.
That's right. Yes,
Yeah.
we
Okay.
did.
But this 13.013.023 applies wholly independently of that. Yeah.
Right.
Okay. Any questions, comments, concerns?
Todd, I sent you a question earlier
Yeah.
about something in the previous set of regulations, back on page 20, but asking an applicant to disclose in their Phase 2 application all political contributions. And I guess my question was, why include that if they're barred from making political contributions as an applicant?
It's a great question, and I think the trick is in, and this is something the
Can
commission.
you repeat that part? It was a great question.
That was a great question.
I don't get that often, so.
That was an excellent question,
All right.
and an astute observation. That it's actually, it stems from Chapter 23K sections, I think it's either 45 and 46 or 46 and 47 that deal with political contributions. One section you have to really read them closely. one section deals with a ban on making political contributions, and the other section deals with the disclosure of certain contributions. So a high-level review would suggest that they're somewhat inconsistent with one another. But I think the way that I would read that, and this is not anything that the commission has ever addressed, I don't think, or voted on in any sense, is that the ban or the prohibition is on making contributions to an individual politician, candidate for office, something like that. There's no prohibition against making a contribution to a community or a division of a community to build a park, widen a road, whatever it is. And it's those type of contributions that have to be disclosed. So yeah, you're right. You can't make a contribution to the mayor or a candidate for mayor or what have you. So to the extent you've done that, I guess you would still have to disclose it, but you're not supposed to do that.
I don't want to.
That was, and I think, if memory serves, there are certain holes in that reading, but that was the only logical reading that I could apply to those two sections. And, yeah, I was just going to conclude by saying the regulations we have here jibe with that reading.
Early on, before you arrived, I raised this question about the statute with the General Counsel to the Office of Political and Campaign Finance, who told me that there are other regulations and statutes that require you to report what you're prohibited from doing. So this is not unique to this statute. It goes beyond, the reporting requirements go beyond, as you clearly explained. But other sections of the statute say you have to report what you're prohibited from doing in certain instances. And so you're hit with a double whammy. If you do it, you can be penalized, and if you fail to report it, you can be penalized. Apparently that has been Fifth Amendment implications of that have been dealt with and found not to exist. So that's something that this statute replicates. So this ably this set of regulations ably carries that forward.
Our regulations don't prohibit anything; they just require disclosure. So we don't have anything that would conflict with the statute.
Okay. Thanks.
Any other questions or comments, concerns? This represents an enormous amount of work by Mr. Grossman and the consultants, and it really is a first-rate set of regulations that I think we can be proud to put before the public in solicitation of comments. We are going to get comments. These are controversial issues. These are regulations that deal with something that has never been done anyplace else in the country, and that is the host and surrounding community and impact of live entertainment issues that we have in our statute. This is a trailblazing effort, and undoubtedly will engender thoughtful comments, and we'll deal with those. But this is certainly something that we can be happy to place before the public for that comment process. So thank you very much for the work that you and others have, the consultants and others have done to create this set of regulations. With that, I would move that the Commission accept these draft regulations and authorize the legal staff to forward them to the Local Government Advisory Committee and to carry out all other steps necessary for their formal promulgation after a period of comment following a public hearing.
Second.
Let me amend that before, if I might. Following a period of public comment antecedent to a public hearing. I think we'll close the comment period before the public hearing, and the public hearing will be the last opportunity to comment. So, you still second it?
Sure. Second with the amendment.
With the amendment, all right. All in favor?
Aye.
What's the schedule now, Mr. Grossman?
Well, so we would file this with the Local Government Advisory Committee by tomorrow. The order requires a 14-day period before further action in furtherance of the Administrative Procedure Act is taken. So we would look to file this with the Office of the Secretary of State by April 12th. And then the law requires essentially a 21-day period between the filing and the public hearing. And the public hearing has to be at least 7 days between the time the notice of the hearing is published in the Massachusetts Register in the hearing. So the public hearing date that we would shoot for would be May 3rd. Certainly, we have to discuss the public hearing itself. We don't have to resolve all those issues right now, but I think a public hearing would have to be held on May 3rd at the earliest. And then, depending on how everything goes, the types of comments we receive, the commission can look to incorporate any comments, and then we can look to file the final regulations for publication at by June 7th at the latest. So that's essentially
Can that May
the whole
3rd
process.
date slide and still make the June 7th date?
We've built in an extra couple of weeks for ourselves, so
Okay.
in theory, we if there are no comments,
Right.
if everyone thinks that this is an ideal document as written, then we could get this done, I think, by May, whatever 2 weeks before June 7th is. So the Secretary of State publishes the Massachusetts Register on a 2-week basis, so you're basically working in 2-week chunks
Right.
here.
Right. Okay.
And so there's no, you don't have to file the regulations anytime after the public hearing. You can file them whenever you want, but that would be the soonest that it could be done.
Right. And we've been aiming for June 7th for quite a while, and we're right on track to make that, so that's terrific. That's great. All right, thank you very much.
Thank you.
Thank you.
Thank you.
The other document that's associated with that is the, Mr. Grossman, we could go ahead and post these, even though the formal promulgation, even though they're not filed with the Secretary of State, there's no reason we couldn't go ahead and post these as soon as they're sent to the Local Government Advisory Committee. Is there or is there? Sorry.
I think we can. I think we also have clearance to do that.
Okay.
Whether we can receive comments on them is a separate issue.
Okay. Well, we can post them with appropriate labeling, and at least people can read them and see what they are and begin thinking about commentary, if we can do that.
That's right. So
Right.
they'll be basically available tomorrow.
Okay.
For public consumption. We'll make the adjustments, so there'll be just one document with no crossouts or anything.
Right, right.
Everyone can see what it is.
Yeah, great, great. The reason I thought about that is that the next document that we have in our packets is the evaluation criteria matrix. And this, too, is an effort to incorporate all the comments that we made on Monday. I don't think we need a formal vote on this. This is going to be further transformed into the application as we move forward. But this is our current best thinking on the criteria, or designed to represent our current best thinking on the criteria we're going to use. Actually, those criteria are in the regulations, but the regulations aren't final yet, as well as the evidence we're going to ask people to provide us in support of their approach to fulfilling those criteria. And if we agree, if there's no problems with this, we could post this tomorrow as well and allow and begin to allow people to think about it so that they can make comments on these as well. So I open that piece up for discussion.
Sounds like a very reasonable plan.
Okay.
I would concur. I think we've talked quite a bit about the different criteria and the evidence. I think hosting them for the process of public comment will be very useful.
Yeah, we've sort of gone as far as we can go on our own. We really need some outside comments now to go further if we're going to. Okay, so we'll post these tomorrow as well as the regulations. Okay. The next item on the agenda is the Racing Division. Director Dernberger.
Good afternoon.
Good afternoon.
Good afternoon.
Lots of rulemaking activity in Massachusetts gaming these days. Don't really have much of an administrative update this week. We're going to be seeing a lot of racing next week at our lengthy meeting.
Could you give us just
I will give you a
the
preview.
highlights of that, some of the?
Yep, I will give you a preview of that. So
Yeah.
we are going to come back to you with the amendments to our proposed legislation and draft report. We made a minor revision in the draft report, and then some language, in particular with some of the absolute numbers that we talked about that appeared in the statute, and some house cleaning as well. We are also going to give you a first quarter update, basically where the racing division is within the Massachusetts Gaming Commission at the end of its first 90 days of actual operational expertise. The things that we've done, the things that we're doing, the things that we're going to do. And that could actually take a bit of time, because there's a lot of, racing as an existing agency has quite a bit of activity. So we'll be putting that before you next week, and we look forward to doing so.
Great, we look forward to hearing about it. There are a lot of really positive changes that are going on here. It's exciting to watch them.
The big agenda item today is what we were calling the Phase 2 regulation changes. This primarily affects the rules governing flat racing, which are found in 205 CMR 4. I do want to bring to your attention, before we dive in, I just want to bring to your attention something that Council has mentioned. It's language that appears in 3 rules, the first of which you'll find on page 32. This has to do with safety standards for safety helmets and safety vests. And in there are design standards that appear. These do appear in the model rule that's promulgated by the Racing Commissioners International. But in Massachusetts, I'm told that the language that refers to the following minimum standards or later revisions, that or later revisions will need to be struck. And so then we will provide the actual standards themselves as well. So the rule will read the same minus the 3 words or later revisions. This appears in this is 411. 411 provision 6 subpart C. You'll also find it on page 41. On page 41, you'll find it in Rule 4.13 provision 5. And that's got 2 subparts A on page 41 and B on 42. The same language appears. It's the same standards that appear in both rules, just some apply to the people that are licensed as jockeys and others are different occupational licensees. So moving forward, or later revisions will be taken out. The documents that you have in front of you, we've got written submissions that were received from the Jockeys Guild, which is a professional organization that represents many of our thoroughbred riders. We have an email exchange from the Jockey Club, which is the breed registry that regulates thoroughbred racing. Regulates probably the wrong word. Governs. And then we've got a submission from Mr. Paul Brooker, who is the paddock plater or blacksmith at Suffolk Downs. And the final thing you'll see is a submission from Suffolk from actually 2011. This has to do with a provision in 205 CMR 6. So we have those written submissions. We have a packet in front of you with the proposed changes that we would like to make. And we have received some clarification from the Secretary of the Commonwealth's office this week regarding the best way to move forward with our rather unique rulemaking process. So I'd like to just talk to you really briefly about that. What we did with the first round was we went through the entire rulemaking process, public comment period and public hearing period, and then at the end voted to adopt them by emergency so we could have them in place prior to the start of live racing, which is now April 15th at Plainridge Racecourse. The reason for that was because of the Chapter 128A, Section 9B requirement imposed on the Commission to change racing regulations, and that's probably a 60-day window that gets added on to the end of the regular rulemaking process. The Secretary of the Commonwealth's office felt the feedback that we got, as we understood it, was that for this Phase 2, that we put these before you today, have you vote on them on an emergency basis, to adopt them today on an emergency basis, and also do a bifurcated vote, the other half of that being to proceed through the regular rulemaking process as well. So starting them out together at the same time in parallel as we go through the regular rulemaking process, finishing that up before the end of the 90 days when the emergency regs would expire.
And the rulemaking process is 60 days, so, correct?
That additional piece, yeah.
Yes. But
No, the additional piece is 60 days.
Right, the 60 days are running in parallel to the 90 days, in other words.
Right, and then we'll have there's a public comment period at the beginning. We'll have to schedule a public hearing for late April as well. So that's in front of the 60 days.
Okay, that is succinctly put. And
I'm
so
not-
this process would start tomorrow, right?
Correct.
The same as the other processes, go to begin the formal adoption process tomorrow at the same time we do the other ones.
Correct.
Okay.
So, happy to answer any questions about the regulations that are before you.
Director, did the written comments that were I believe there were 3 of them, correct? Were they, did that change anything in the proposed rules? Was anything incorporated?
Yes, many of the amendments, many of the submissions basically requested that we amend language in our existing regs.
Mhm.
The existing regs, really with the running of the race, were model rules that had been adopted, I think, in 2008, and just had not been updated since that time. So a lot of what you see in the red line version have been put forth by the stakeholders, just saying this is the current model rule, and we ask that the Commission update. We would note that some of them have been adopted in practice at Suffolk as a house rule.
Yes.
This allows the Commission to have its regulatory authority and weight behind that. And I would also like to point out something that I missed earlier, which is live racing at Suffolk may not start until June 1st, but the backside area where the folks come in with their horses and begin training actually happens in mid to late April. And so some of the occupational licensees are affected by the safety vest and helmet requirements here. And so that's the need to get these going quicker rather than later.
Also, it's nice to see such a positive letter from the Jockeys Guild with regard to all the changes that you've recommended we make and we're making on to be in keeping with best practices. It's a very, very positive letter. It's nice to see. And we owe those accolades to you, Director.
The Commission, I would say. Commissioner?
Well, you're leading the way with best practices in the industry.
Yeah, I think that bears underscoring. I think that the changes that we're making here really are terrific to watch and to see as we emerge on the frontier of good practices throughout the country, and it's really exciting to see this process in motion. So I also think that reading these regulations, anybody who's been to a race, reading these regulations really is a fascinating guide to what's going on. I mean, you think about all the various steps in getting the course, now I'm thinking about the thoroughbreds, but the same thing applies to with which I'm more familiar, frankly, but I'll become more familiar with the standardbreds as you proceed. All the steps that take you from the time you first hear the trumpet to the time you hear the drill.
Wasn't
and
quite,
everything
yeah.
And each one of those has got its own little regulatory halo, if you will. It's all a carefully choreographed piece of a very beautiful sport. So it's fascinating to read these and understand that.
And I would add racing officials in place at each racetrack that enforce each individual piece of these rules as well. And actually, that we could talk about that very briefly. Our Phase 3, if you will, rulemaking, which we're going to take a break from rulemaking and racing for a while, but over the fall we're going to look at the definitions of the different racing officials in both 205 CMR 3 and 4 and their duties vis-a-vis what are currently recommended with the model rules, the USTA rules.
This is really wonderful. We got drills, we got...
Shoeing a horse.
Yeah, drills, we got... So the ceiling's got to come down in a minute.
At any rate, so actually we'll be looking at all of those sort of housekeeping things over the fall on a non-emergency basis.
Great.
Excellent.
Great work.
All right, any questions, comments? So then I would move that we adopt the proposed changes to 205 CMR 4.00 that are before us on an emergency basis, and that we simultaneously commence the formal promulgation process for those rules by sending them tomorrow to the Local Government Advisory Committee and by authorizing Director Durenberger in conjunction with the legal staff to take all other steps necessary to have them promulgated formally.
Second.
Any discussion? All in favor?
Aye.
Thank you very much.
Thank you, Director. Good work.
Anything further?
This concludes the Racing Division's agenda items for today.
Okay, great. Thank you very much.
Thank you.
Mr. Chairman, we'll need a short break.
Yes,
for the
we're
next
going to take a very short break now so that we can prepare ourselves for the next item on the agenda, which is the research agenda, item number 8 on the agenda. So we'll take about a 5-minute break. All right, we're prepared to resume the 61st meeting of the Gaming Commission at 2:05. And the next item on the agenda is the research agenda. And Commissioner Zuniga, I will turn that over to you and let you carry it forward from here.
Thank you, Mr. Chairman. With us today is Dr. Rachel Volberg, Dan Hodge, and participating over by phone, we were able to reach also Rob Williams. I would characterize them as principals of the team from UMass Amherst who responded to our research agenda RFP. This commission acted on a recommendation last week to further this effort. And one of those actions was to invite you today to help us understand the nuances a little better of this project. It's a project that I was involved in evaluating, and has been a very good learning experience for me. So we're happy that you're here with us today to help us and our public, and as well as the record, show that the efforts that we want to undertake. Most of which is directed by legislation, by the way. So just want to turn it over to you, Dr. Volberg, and take it away, please.
Okay, thank you very much. Thank you, Commissioners, for inviting us here. I don't know if any one of you can tell, but this is perhaps the most exciting day of my professional life. I have been working towards a project like this for approximately 15 years, and it's truly amazing to me. It's pretty much a dream come true. So I'll stop with my blithering.
Well, it's not blither. Could you just expand on that? Why?
I've been involved full-time in gambling research for 28 years. And over that time, I've been involved in literally hundreds of gambling studies. And there is not a single jurisdiction in the world that has enshrined in its legislation the need for research to monitor the impacts of a new form of gambling over time. And it's actually something that I started thinking about and talking with quite a number of years ago, 15 years ago, when I was involved in some very large research projects in Sweden. And the Swedes have some wonderful approaches to social science and to using research to produce empirical evidence and create evidence-based approaches to social problems. And in our discussions, we talked about, sort of what would the best public health tool available be if you were looking at introducing a new form of gambling. And at that time, the Swedes were looking at introducing casinos. And so we discussed the importance of a monitoring system so that you could look at impacts and see what happens when you introduce a new form of gambling, but then continue to watch those impacts evolve, because no one knows for sure, but we speculated that there might be very significant positive impacts at the beginning of tax revenues and jobs and tourism development, but then over time that might be balanced out and perhaps outweighed ultimately by some of the negative social impacts. And unfortunately, that remained a dream. The Swedish government did not until very recently actually implement something like this, and frankly, they've gone in a slightly different direction. But every jurisdiction is unique, and some years ago, as I realized that here in my home state of Massachusetts, that it was very likely that we were going to have casinos, I started thinking about how would we possibly make something like this or get something like this built in Massachusetts. And I called on my state senator, Stan Rosenberg, and said, sent him a little email saying, I'm a constituent and I'm a gambling researcher, and if you're ever interested in talking about some ideas for research, please give me a call. And practically an hour later, it was literally almost immediately, I got an email back from him saying, I'm very interested in meeting. Why don't you come over to Amherst and have coffee? And so we met and had coffee in one of the lovely little cafes in Amherst, and sat for several hours. And I gave him basically a large number of documents, many of them with links to websites that he could explore, what I thought were some of the best in the world practices around research. And we sort of kept in touch intermittently. This was back in 2008, I believe, and and so I watched from afar as the legislation developed, and lo and behold, when the first casino bill was passed out of the legislature, it contained what I consider to be some of the most best language around ensuring that research would happen in conjunction with the introduction of casinos. And I could very much see that the best practices that I had pointed Senator Rosenberg to had actually been incorporated into the legislation in Massachusetts. It was a very proud moment to actually see it in legislation. And I realized that I now had the next extremely daunting task was to try and get the project so that I could participate in it. And that's what I've been involved with for the last year.
Great. All right. Well, sorry for that interruption, but that's fascinating history. So
Great story.
It's not that much of a digression, because on our next slide, this is exactly what I think our proposal brings to you and to the Commonwealth, because I consider this proposal and the study that I believe will come out of it is going to be a tool that will be of value to every single citizen of the Commonwealth of Massachusetts. I think it will be valuable to the applicants, to the operators, to you as regulators, but also to legislators and to many people who are simply interested citizens in host communities and surrounding communities and elsewhere in Massachusetts. I guess I would take it even further and say that there are a lot of international eyes on this project as well. The project is intended ultimately to generate early warning signs of potential changes in the social and economic impacts of new forms of gaming in Massachusetts, and we're certainly looking at casinos. But as you've said a number of times in these meetings, internet is on the horizon, and we'll be looking at that as well. And I think from my perspective, it's really important to understand that we are going to be able to use the information that's generated in this study to essentially incorporate evidence-based and empirical data into the development of measures that will minimize harm associated with casino gambling, but also with internet gambling in the future and whatever the next iteration and future holds. We bring a highly experienced, multidisciplinary, scientifically rigorous, Massachusetts-based team together. I didn't wait for the RFR actually to come out before I recruited Rob Williams. He assisted us in the response we made to the request for information. Rob unfortunately can't be here physically, but he is the author of the study that Chairman Crosby has cited a number of times, where there was a very thorough review of all of the impact studies of gambling that had ever been done, and of the 492 studies, only 7 of them were rated excellent. And I felt that Rob had a tremendous amount to bring to Massachusetts as a result.
So we hope there will be an 8th one.
We hope, we fully anticipate that this is going to be the not just the first of its kind, it's going to be world-class. And we are going to be, I believe, a shining example to many other jurisdictions, both here in the U.S. and internationally. And growing out of the involvement with Rob, we are presenting a state-of-the-art analytic framework for studying these issues, as well as multiple methods research strategy. And when I say analytic framework, I want to just emphasize that this is you know, based on the review that Rob and his colleagues did. They had a number of important lessons learned out of that. One was that it was important to measure impacts rather than costs and benefits. Another was that it was...
What's the difference?
Costs and benefits tend to have monetary amounts applied,
Okay.
whereas impacts can be qualitative,
Okay.
can be difficult to quantify in terms of money or even in terms of, you know, how many people are affected by a divorce, for example. And so the idea here is that when you're assessing the overall nature of the observed impacts, it's important to understand that these sometimes involve qualitative assessments or some element of subjectivity. And people are not going to necessarily agree on whether an impact is good or bad, but at least we can all agree that it's an impact. You know, I'll let Dan talk to the economic part of it, but you know, there are things that, you know, a casino has restaurants and people go to those restaurants, but they make the decision not to go to the, you know, the coffee house down the street from their home. That's a negative impact for the small business owner, but it's a positive impact for the casino and potentially a neutral impact for the Commonwealth, which is still going to get revenues one way or another from the sale of the coffee, whether it happens in the small business or if it happens in the casino. So, and then the final point about our proposal is that we designed it very carefully so that we could examine the impacts of casino gambling at the state level, at the regional level, and most significantly at the local level, at the level of the host communities. And we're very excited about that particular piece of the proposal. This is I guess you'd call it a timeline. It's pretty high level, 30,000-foot timeline. But I want to sort of use this diagram to speak a little bit about the design of the study, because it is quite complex and can be a little difficult to get your head around. This is my copy of the proposal, and I'm sure you've all had to wrestle with the same amount of paper just on this one issue. We took a very careful read of the Expanded Gaming Act, and in particular Section 71, and after lengthy discussion, we elected to propose a cross-sectional rather than a cohort design. And I have to say that it's important to just emphasize that both Rob and I have experience with conducting cohort studies of gambling. I'm involved in 3 studies. Rob has been involved in 2 such studies. And so we understand what that kind of design is intended to accomplish. And we felt after reading through the Expanded Gaming Act that this repeat cross-sectional approach was preferable in terms of what the Commission has basically been told to do by the Expanded Gaming Act.
Could you just, for my benefit, and
Sure.
I'm sure the benefit of others who may be watching from afar or here, explain the difference between the 2 different kinds of studies, and then to say why the cross-sectional study, in your view, is more in line with what 71 is looking for?
Absolutely. I don't know if you remember when I presented to the Commission at your problem gambling forum.
Right.
And I had a slide that it was a little camera, and then it was a film strip at the bottom. And that slide was my somewhat naive effort, perhaps, to try to illustrate what the difference is between a cross-sectional approach and a cohort study. So a cross-sectional approach, if you look at the graphic and you look at the column, the third column over that says General Population Survey, you'll see that in 2013, we've got the box is highlighted, and then again in 2018. And if you want to think about those as sort of the camera, okay, so we're going to take a snapshot of the population in 2013 and then a snapshot of the population in 2018. And that's a cross-sectional approach gives you these snapshots. But we know that really what's going on under the surface is a movie, and so there's things going on. And a cohort study is intended to give you information, or is intended to yield information about how individuals change over time. Because as we've been learning, people don't develop a gambling problem and then just stay problem gamblers forever. They cycle in and out, and sometimes quite frequently, so that in the study that I'm involved in Australia, we were interviewing people every year for 5 years. And we had people who started as a problem gambler at time 1. They weren't gambling at all at time 2. They were gambling a little bit at time 3. They weren't gambling at all at time 4. And then time 5, they were problem gamblers again. And if you had just taken the snapshots, you would have thought they were a problem gambler both times. But there was all of this different behavior that was going on underneath. So that's the movie. But it's an individual movie, and people move in and out, and there's lots of sort of movement. But my reading of the Expanded Gaming Act is that the concern is about communities. And a cohort study, unless you had a sample just of the community and followed all of them over time, would not be able to tell you what was happening at the community level. And so that's why we are proposing a cross-sectional survey, or survey approach.
But just to say it simply, because I feel like maybe for everyone's purpose, it might help to say it simply, right?
Absolutely.
The cross-section means that you're going to do a survey of the population at a couple of different points in time.
Right.
The cohort would mean that you would generate a sample, get those that population, and then track those particular individuals every single year over time.
Okay,
Right.
yes. Those same individuals,
So-
or as many of them as you could keep.
Even if they moved out of the community.
Even if they moved out of the community, if they moved out of Massachusetts,
Right.
yeah.
You'd
You-
find them. or
You would
the
try to
study
find
would
them,
try
and
to
you would
find
try to
That's-
find them.
That's one of
Yes.
the costs of the effort.
Well, and that's a particularly key point with particular groups that Dr. Wolver mentions. Transient populations escapes the cohort. Students in Massachusetts is a particular subgroup that may be of interest. What happens to students, let's say, by virtue of casinos being now in Massachusetts?
Right.
Just for example.
So, but let me just add to that, that we never intended to discard the idea of a cohort study altogether, because the Section 71 is written in 3 parts. So the first part is you have to do a baseline study. The second part is you have to do the social and legal factual studies, or I think I said that right. And then the third part is you're required to do individual studies. And one of the types of individual studies that is required is what's called an etiological study. And what that means is the natural history of people's gambling careers. And so I've known from the beginning that eventually there needs to be a cohort study done in Massachusetts, based on my reading of the statute at least. And so when we obtained costs for data collection for the cross-sectional surveys in Massachusetts, we made sure that they built in enough in their budgets to enable us to obtain what's called contact information from people. So believe it or not, people who participate in surveys actually will give you enough information so that you can go and find them later. And so we would have a very large sample of people who had agreed to be recontacted and had given us information to enable us to do that at some point in the future when, when the time is right to do a cohort study. We will be able to do that in Massachusetts.
Thank you.
Okay, so I think that's probably the main point of this slide, that I wanted to make sure that we were able to discuss the difference between a cross-sectional and a cohort study. This slide basically is intended to show you that we have many multiple streams of data collection that will take place over the course of the study that we proposed. You can see we have problem gambling treatment and prevention data, a lot of secondary data. We have these population surveys. We have information that we're going to collect from the gambling venues and from state and federal governments. We have a casino patron study planned, and a continuation of the license plate surveys that are already being done. And then we are proposing key informant interviews and focus groups in the host communities. Each of those streams of data collection is assigned to a clear group or number of scholars, researchers. We have a full-time research manager planned and a data management center where the data in a carefully redacted manner, to use a legal term, is going to be made available to the public, so that people are going to be able to access this data and will be able to use it for their purposes. This is not going to be sort of a silo that we're not going to let the data out. We have a very strong executive management team, myself, Rob Williams, and Ed Stanek, who's the chairman of the Department of Public Health at UMass Amherst. We are going to be the central body that provides for the coordination and integration of the results, so that you, the commissioners, don't have to sort of comb through all of these data streams and figure out what they say, but we are going to be working to provide reports and information in ways that are useful to you and to others in the Commonwealth. And then finally, we have at the top, we actually have a Canadian, an Australian, and a Massachusetts resident whom we've proposed to serve as peer reviewers on behalf of the commission. They will be reviewing key deliverables on our project and reporting back to the commission about whether they have concerns about those deliverables. And if they do, we will respond to those concerns, and we will make sure that what we're doing is scientifically defensible. And this is my last slide, and then I'm going to turn it over to Dan. In preparation for this presentation, we were provided a copy of the proposal that was submitted by the other top contender for this project, and asked to consider what we might change or what we might propose given some of the features of the other group's proposal that were deemed desirable. And so this particular area of comparing the baseline survey approaches is what I specifically am looking at, and Dan is going to speak to some of the elements of the economic piece of the proposal. But you can see that there is a very large difference in the size of the sample that we are proposing for the baseline survey versus the 6,000 person cohort sample. Both of us actually had proposed an address-based sampling approach. So I think we're all on the same page there. The address-based...
What's an address-based sampling?
I'm sorry. So let me put on my glasses here because fortunately NORC, our data collection folks, provided me with some talking points. Address-based sampling involves sampling addresses from the U.S. Postal Service's, it's called the Delivery Sequence File, which lists virtually every residential mailing address in the U.S. It can be purchased from commercial vendors, and it is considered much better than a telephone sampling frame for many reasons, but primarily because people's addresses are not going to change as frequently as their phones might, that you can do all kinds of address matching and reverse matching, so you can get names and addresses and phone numbers aligned. So this has really been a boon as telephone response rates have dropped. Address-based sampling has really moved to the fore.
Okay.
We had originally proposed a multimodal method of data collection, as the other team did. However, ours was based on a self-administered questionnaire, followed by telephone approaches, followed by face-to-face with people that we couldn't get by the previous two approaches. The other team proposed a web and interactive voice recognition approach for their first approach, followed by telephone and face-to-face. When I spoke with the folks at NORC, they said they absolutely could do a web-based approach, that they felt it probably was a good idea because of the number of young people in Massachusetts who will be more comfortable with an online survey. But they felt that it was important to include the self-administered questionnaire, excuse me, because there is actually evidence that older people, older adults, only about half of folks over 65 have internet access. And so half of the older population would not be able to participate in a web survey. And so the self-administered questionnaire, excuse me, would get us people who were who didn't have access to the internet, in an easy way. So all of these, the address-based sampling and using multiple sequential modalities to collect to complete the interviews get you much higher response rates than telephone surveys. When we were putting our proposal together, however, and we were looking at the costs, frankly, I was not optimistic that we would be able to do an address-based sampling approach. It seemed very, very much more expensive than telephone. So we proposed three, as requested in the RFR. We had a low, a middle, and a high proposal. The address-based sampling approach and the multimodal data collection was really only our highly robust, it was only included as our highly robust option. So we're delighted to be talking about doing something of this quality. I think I'm going to let Dan talk. There's a little bit more information about recruitment and, like what's the best way to get people to cooperate with you once you actually make contact with them. There's not very many differences, but I think let's get on to the
And the numbers, before we do that, are the numbers, the 10,005 and 4, are those target numbers, or you keep going until you get that many?
I would say it's somewhere in between. We are going to get as close as we possibly can to those numbers. I think the 5,000 online is not going to be particularly difficult. It's not going to be particularly expensive either. But it's intended to give us a much higher yield of problem gamblers, so we can look at impacts. The 10,000 we and the 4,000 targeted, we budgeted for those numbers. But, you know, in the real world, it can sometimes be more challenging to get the data collected than you anticipated, or, you know, something makes it more difficult. I will say that when we did the California, I worked with NORC on a very large survey in California, and we had projected a final sample of 7,500. We achieved 7,121, which was well within the same, it didn't change the sampling error or any of our confidence intervals at all. It wasn't quite the 7,500 that we had hoped for, but actually what happened in California was we ran out of time rather than money.
So as long as you're within the same sampling error as these numbers indicate, you've got enough.
Yeah, I mean, if we missed by, you know, 500,
right.
It would have very little
right.
impact.
Okay. Okay.
Okay. Dan?
Thank you. My role is to focus on the economic research aspects of this project. As you all very well know, when the casino and gaming legislation came about, two of the overarching objectives were related to, you know, jobs and economic development, and also an additional revenue source for the state. And so, you know, these are really key aspects of the research that we're doing. And what I guess I'd like to emphasize is that our goal is to really be looking at the net economic and fiscal impacts. There are lots of predictive studies that have been done on the economic impacts of casinos. Many of those do not explicitly account for some of the offsetting types of effects that you are likely to see and experience. And so what we have tried to do is you know, kind of boil it down in terms of what are some of the key drivers or what, you know, factors for net new economic activity. So in addition to the overall, you know, scale of investment, and just in today's Globe, I saw unveiled a proposal for the Wynn one in Revere.
Everett.
Everett, sorry. Thank you. And so in any case, so we'll be looking at both the gambling and the non-gambling revenue, both how much revenue, and that relates, of course, back to how much state revenue will be accrued or obtained through these facilities. And then in particular, and the point I like to emphasize is the mix of visitors and spending between recapture, some Massachusetts residents who otherwise would gamble outside the state but will stay and spend their money at facilities within the state, out-of-state visitors who are attracted due to these facilities, and then in-state redistribution, and that's something that we definitely need to take into account in the some of the different surveys that Rachel alluded to, including the license plate one, where we're really getting a good understanding of the patrons at these facilities, is going to help us to measure that. And I guess that brings me to my other kind of overarching point, is that this is not simply a predictive study. This is a multi-year research project, and the whole point is to actually measure impacts as they occur over time. You know, the reason that there's a couple of surveys at the beginning before the casinos are introduced and then after is not to guess at what the impacts are, but to measure them. And the same theory applies to the economy. Other factors relate to expenditures by these facilities on different suppliers and vendors in the state, the employees at the facilities, where do they live, what kinds of jobs did they have before, were they previously unemployed, and a lot of the research that goes into this project will actually get at those kinds of questions. Scale of infrastructure investment, both at the facility and some of the supporting transportation and other infrastructure that's involved.
Dan,
yes.
just a quick question. As it relates to employees at facilities in the categories you're talking about researching, we keep hearing about casinos potentially going out and recruiting somebody who's already employed from banking or any other industry, and that that obviously creates a backfill. You're going to be able to measure how much of that movement is between people who are already employed just moving to another position and having that backfill of maybe potentially by somebody unemployed?
Yeah, definitely.
Yes, I mean, because part of the data collection, there's both secondary sources through, traditional government data, but also a fair amount of primary data collection directly from the facilities, which includes an employee survey.
Right.
And so, as an economist, that's an interesting kind of question, because why would that person move from one job to another? Well, they would only do that if that individual was better off. So there's some incremental, benefit there. Typically, why stay at a low-paying job when you can have a high-paying job, or whatever the various amenities are. But yeah, that kind of those kinds of dynamics, including whether you were unemployed before getting the position or whether you lived in another state, right, directly before getting the position, are the kinds of information that we'll be pulling together.
Let me emphasize a key point there, which is that we're all assuming that we will obtain a lot of very important information from our applicants on their level of spend, on their level of employment, but very importantly on the level of gaming when these operations are up and running. And there's ways that the statute deals with to anonymize data. For this commission to be able to capture that data anonymously and be able to test behavior and changes.
Yes, and in fact, that particular section of the legislation, I want to say 92, but I could be wrong.
91.
That was actually originally an amendment that was drafted at the request of a couple of the senators that were involved in drafting the legislation by Natasha Schull, who is a cultural anthropologist at MIT, who has done a great deal of work looking at gaming machines and gaming machine design and designers. And she actually consulted with a number of her sources about what kinds of information these machines might be able to provide for research purposes. And that was language that was incorporated into the legislation itself. And and I should say that Natasha is on our team. That was the final important point.
There are a number of complicated dynamics that go along with facilities of the scale that are being proposed, and what we are proposing as part of the research is similar to what Rachel was describing in terms of multiple methods, is combining both a number of economic and fiscal metrics which we will track over time. So, jobs, unemployment rate, and other kinds of factors, business startups and failures, and having a database that we will track over time so we can look at changes and try to, especially in the communities and in the regions where the facilities go in, basically attempt to isolate or find evidence for, the impacts that you may expect. But we're also proposing to do econometric modeling, both to, when these applications come in, they're going to have their own estimates of how many people will work there and how much revenue they'll generate and other kinds of effects. And what we've proposed as, at least as an option for the commission to consider, is that using what's called the Regional Economic Models, Inc., or REMI model, is that as those applications are, or the licenses are selected, and we know which facilities are moving forward, would then be to take that information, do a careful predictive assessment that we can then, as they get implemented, track to see how closely our best predictive methods can actually correspond with the actual impacts that we observe as the casinos are built and operated.
How do you control for non-gaming related influences on the, whatever delta comes up?
Well, that's a good question. So there's two different ways that we, in essence, plan to do that. One is when the facilities actually come online, we'll be able, through the different surveys and such, we'll know, well, how many people actually are working at the casinos. You
Right.
predicted 4,000,
Right.
but is it 3,500?
Right.
And out of the 3,500, how many are actually full-time, or what wages are they actually being paid? So we'll have actual information at that point, which we can then put, again, back in as inputs to the REMI model to try to do it that way. The other piece that we are going to do in parallel is along the lines of trying to track different metrics. So in particular, or as an example, something like jobs or unemployment rate. Well, the question is, how much of any change in jobs or unemployment rate can you actually attribute to the introduction of casinos? And this is kind of a age-old question in all kinds of fields. But the idea, in essence, is to try to look at, just like you might in experimental analyses, try to identify control groups. So other communities or regions or parts of the country that did not have this kind of change introduced to it, what kind of trend did they experience? So, some of the impact of any community in the state and the country is related to, larger macroeconomic factors. So there's different kinds of statistical tests that we plan to undertake to try to better isolate those effects. It's I would say humbly, it's never perfection, but there's a lot of ways that you can try to build some good evidence on the magnitude of the effect.
Can you do the same thing, Doctor, for non-economic changes?
Social
changes?
I guess I would have to get together with Dan and figure out exactly how we would do that. I think there probably are ways. It might be difficult to assign specific numbers, or if you didn't have casinos, or if you introduce casinos, you get X number very precisely of new problem gamblers.
But you're going to look at things like the crime rate, right?
We are going to look at things like that, yes.
So the crime rate could go up because of, in a gambling impacted area, it could go up because of gambling factors, or it could go up for a whole variety of other factors.
Right, it could go up just because you have more people in the area, and you have to be very careful about the denominator. What is the population that your crime rate is on top of?
Right.
And yes, we'll certainly be able to look at things that can be quantified. We will be able to do the same kinds of modeling.
Right. I mean, in essence, something like the crime rate, where you're basing it off of publicly available data that's available, say, for other cities, towns, states, then you can use, just like you could on economic metrics, you can, see what the control or other trends are to see if there's a differential kind of rate. So there's some similarities, especially for kind of government or secondary data sources like that.
Right. And there are also, as the other proposal pointed out, there are sort of indirect indicators of, say, problem gambling that can be monitored over time. Things like rates of domestic violence and, you know, bankruptcy and various things like that that can be monitored. And we actually did in our highly robust proposal envision doing something very like the social indicator approach that the other team proposed.
At a base level, and let's talk about base level of business closings, business success. I mean, is there enough public information available about business closures that you can establish a baseline in a region and then look at it after the introduction of gaming? I mean, businesses close for any number of reasons.
Right.
Trying to narrow it down to say this business closed because of the introduction of expanded gaming. But on the flip side, turn around and say, you know, growth in business taxes in a particular region, pre-introduction of casino gaming and maybe related industries. I mean, you could really delve into things on the business impact side 50 different ways.
Right, yeah, I mean, there's gonna be a lot of information to try to sift through, and when it comes to something like business establishments, you know, there's very regular data that's tracked on the number of establishments, and there's some information on, you know, net startups. Part of what we plan to do, in addition to quantitative data, is to do basically on-site what we call key informant interviews. So, you know, this isn't just us doing all of our work in our, you know, little office and plugging away the numbers. It's, you know, we need to go to the towns and communities that are impacted, talk to the various, you know, local economic development, chamber, other, you know, groups, and get some, you know, hands-on contextual information about, you know, what some of the effects are. You know, the data can take you pretty far, at least in my experience, but having some of that context of what's happening on the ground can hopefully shed more light on it.
Dan, of the 400 some odd gambling studies, 7 of which were deemed excellent, did anyone track fiscal impacts as comprehensively, to your knowledge?
Well, I can tell you that that the fiscal impact side is very often, you know, part of a reason to do casino legislation. I worked on a project in Indiana, so my background includes a number of different kind of economic consulting type positions, but my first one was actually working at this company, REMI, where we did economic impact modeling for different projects across the country. One was in Indiana. When we did that work, you know, one of the very careful aspects of the project was, okay, of the proposed, you know, casinos, what percentage of that is coming back to the state, and then how do we treat, you know, that portion of additional revenue that's expected from a fiscal standpoint, and possibly either allowing for additional you know, investment that wouldn't otherwise be there, or a more healthy fiscal situation. It's an unusual form. I mean, I don't want to say it's free money. It's not free money by any means. And as I was trying to get at where that spending is coming from impacts a lot. You know, how much of it is actually net new to the state. But yeah, that is a very important part of most of these analyses.
I'd like to also see if Rob can chime in. We've got him sitting here even though he's not visible. And Rob, you might be able to tell us something about that as well.
I actually didn't hear the full question.
Rob, has the 7, let's deal with the 7 that you deemed to be excellent. Did any of those 7 track the fiscal impacts as comprehensively as they're laid out here?
Oh, yes.
Okay.
Yes. I'd say the majority of those were rated excellent because they cast a very, very wide net and measured all aspects of economic changes using control conditions in addition to things like key informants and gaming employee surveys, where you can make a more direct causal attribution of the impacts. So yeah, most of those 7 did in fact use a similar methodology.
Thank you.
So to keep us moving, similar to Rachel, I had a chance to review the economic research elements of the MGame proposal. I guess I would put it in the spirit of trying to make sure that what we're doing is as high a quality and as can be, and put together a few of the different sort of elements. The first one, kind of reading across row by row, there is as I've been talking, we've placed quite a bit of emphasis on measuring both actual and estimated impacts and tracking metrics over time. In a lot of ways, this is set up to be a version of like a before and after kind of study. We're still in that before stage, before the casinos are implemented, and then being able to measure and trying to estimate actual impacts. The other proposal, at least in my read, emphasized modeled and estimated impacts via the REMI model. In my view, because we do also incorporate REMI, I don't anticipate any change there. In terms of the REMI model, as part of the level of I guess budget or funding that's been explained at least to me, what's included there was a what's called a 160 industry sector model, which would be based on 4 regions of the state. My thinking being one for each of the 3 casinos, resort or destination casinos, and then a 4th region that makes up the rest of the state. I wasn't sure about the configuration planned in the other one. It may have included additional regions. I guess I would suggest that whether with the commission or some group, it's probably worth talking that through, because that is a significant kind of modeling purchase as part of our project, and I wouldn't want there to be any surprises. And once you launch down the path of configuring a model, that's what you're working with. So that will may benefit from some additional discussions as we get going. It's also not an element that we need to do tomorrow. We place some emphasis on accounting for both economic, which I mean in terms of things like jobs and gross state product and wages, fiscal, which really gets at government revenue and expenditures, and then there's other strictly monetary effects as well. To some extent, the other proposal was combining some of those effects. I don't anticipate a change in that element of our proposal. They did, on the fiscal side, recommend some customized fiscal spreadsheets. I think we want to take a careful look as we get going in terms of the fiscal data sources that we would be using to ensure that we really have as strong a set of information and framework as possible, because as Commissioner Cameron pointed out, looking at those fiscal impacts both at the local and state level of these facilities is going to be essential. And then another element that comes into this is the potential for there to be some population migration. So as these facilities are implemented, with the number of jobs that are planned, whether it's within state or folks coming from nearby states, You certainly could expect some population in migration. The M game proposal emphasized the use of IRS data based on tax returns. Our group at the UMass Donahue Institute, we're actually the state data center through the U.S. Census, and we do the population estimates for the state. We will take a look at, basically to ensure that our methods and our data collection are what is needed for this project. I think that we have more than enough of the capability there, given the fact that we're doing the year-by-year population estimates for the state. But that is something, that is an element of data that we'll make sure to take a look at. I'd certainly, if there's other elements of the, proposal as we get going that you have questions on, I'd be happy to discuss that.
All right, all of that is enormously helpful and succinctly presented, and so thank you very much. Are there questions or comments that anybody has? I have a question. I have a couple of questions. I'm not sure that you're the right target for those, but my first one is how do we pay for this?
Yep, that's a very important, good question. One of the best things of the legislation, in my opinion, relative to this arena is that it really gives this commission the tool to fund quite this effort. And I'm referring specifically to the Public Health Trust Fund, of which we are trustees. And the legislation sets a floor that we assess on an annual basis. But there's also there's a particular tax that also from the gross gaming revenues that funds these trust fund in later years. Because there's also this mandate of a baseline study, one that needs to happen soon, because population behavior will start noticing some impacts, if you will, very soon. There's a need to fund that now, right? In our estimation. So my intention is, or my recommendation as well, is that as soon as we can assess our applicants the floor for that public trust fund, that we would, commensurate to the size proposed by their proposals. Technically, we would fund, we would quote unquote front that effort for some short period of time, and then continue funding it as soon as we have our applicants become licensees.
So initially, we would pay for this out of operating revenues that come to us from the slots, machine taxes, and the ability to assess for operational costs?
Well, not necessarily. Initially, as of next month, right. We would use our initial funding to start funding this effort. Once we have our ability to assess applicants for the public trust public trust fund monies, my intention is that we do that, to continue funding this effort.
And that is the public health, the $5 million?
That's correct. The
$5 million annual fund?
Correct. That's what I refer to as a floor. It's a public health trust fund.
And that is something that we have the ability to do as soon as we grant a license, at least
as per the current regulations recently adopted. Right. Yes. Right. Yes.
Okay.
Now we'd have to think about the details of how to do that proportionately to the applicants, and we'll cross that bridge when we get there. But effectively, yes.
Okay, so that ties into my second question. What is the role of the Gaming Policy Advisory Committee, under whose advice we are with whose advice we're supposed to be engaging in these studies?
A very important one. As the legislation reads, the Gaming Policy Advisory Committee sets the annual research agenda.
All right.
By some interpretation, that could entail, that should entail a lot of what's envisioned in this project, that will entail. But there's these timing consideration that we need to be aware of. What we really need to do currently, which is why we did this RFP, is undertake this baseline study.
Right.
And setting up the systems and scoping out the effort. And this advisory committee has not been in place for a number of reasons, not the least of which is that our applicants and some of the leaders of the communities where these casinos will go have a seat at the table at that, at that committee. So this committee will come to fruition, hopefully not too long in the short future, but we need to do this effort before it's too late, for lack of a better term. Do you want to expound on that?
If I could just add to that, I was very cognizant of the fact that the Gaming Policy Advisory Committee was A, supposed to be overseeing the annual research agenda or assisting with that, and B, would not be in place for, at least the first section of Section 71 activities. And so when we wrote our proposal, we had as specific deliverables reports to that committee as soon as it was stood up. We were proposing to report to the committee 2 months before the annual report to the legislature is required about the annual research agenda. So that my vision was that that we would be feeding information on our data, on our research activities to the committee and to the commission in a timely way in order for the committee and the commission to then report to the legislature.
And I should add that this committee is advisory in nature. It's an important advice, but the discretion, as I read the legislation anyway, remains with the commission.
Yeah, it is. It does, but it does. Okay, I understand what you're saying. Any other questions?
Just one quick question. We are currently in the process of recruiting and hiring a director of research and problem gambling. How would you see your interaction with a person in that position? Beyond the obvious ones.
Beyond the obvious of reporting to them on our progress. I actually was thinking about that this morning as I was driving in, and thinking that there are a number of conferences coming up, for example, on problem gambling and on gambling research that I've been attending for many, many years on a regular annual basis, and that whoever the director of research and problem gambling turns out to be, if it's not someone who is already in the field and has a background who is very likely to already be known to me, my thought was that this was someone who would certainly be able to attend those conferences and benefit from the introductions that we could make. I think the same thing on the economic side, that this is someone that we would plan to work very closely with in terms of not just communication, but and networking, but also in terms of the various decisions that have to be made about what what does this research say about decisions that the commission needs to make, and how can it be fed through through your staff to you to make the very best decisions.
Okay. That's helpful.
All right, thank you very much.
Thank you.
Thank you, very,
Excellent
very.
Thank you.
presentation.
Mr. Chairman, do we need to, I think last week we had a motion to.
Yeah, we do have a motion, and I want to come back to that motion. The motion, the recommendation is that the Gaming Commission authorize Commissioner Zuniga to begin the process of further refining the scope of work and undertake contract negotiation and execution for the research project with the team comprised of UMass Amherst as part of their response to the RFR, yada, 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 which I'll spell out in more detail in a second. I think and we ought to act on some variant of that today, or that. It seems to me clear that the focus on the communities as opposed to the people who may migrate, people who may remain in the communities and migrate out, is a sensible way to go, and to measure both the economic impact on the communities and the impact on the population that's in the communities is really what the guts of our mission is. And it seems to me this is really, as all of the background work by the project management team reveals, a very robust and well-qualified team. This is a great team to do this. My one, and I understand that the Gaming Policy Advisory Committee isn't here, and we have to have a baseline. I mean, otherwise, a lot of the value of this is gone. So all that's clear. I am a little concerned about the cash flow piece. So I wonder if it makes sense to say, let's go ahead and do the negotiations. Let's get a contract. Let's get, with the contract, a projection of a cash flow, and match it up with our budgetary projections. And then let's bring that back to the commission, saying, this is what we propose to do, this is how much it's going to cost, this is when we're going to incur the costs, and see how that fits into the overall scheme of things. Does that make any sense?
That makes absolute sense. We could certainly do that. We should.
We need to move quickly, and I
we
understand
need to
that.
move. There's a time element, but we could easily mobilize, and to some degree, they started to do this. A projection of cash flow for the next, the remaining of this fiscal year or the next fiscal year. It should really be the next fiscal year as well. And that's all subject to ratification and approval, as any large commitment,
Right,
monetary
right.
commitment is of the
Right.
commission.
Right.
So we could certainly come back soon with all that information.
No, I
Any
think
other thoughts
that's
about-
reasonable, considering it can be done quickly.
Right.
And that would give us more information to,
I want to make a point that is a little indirectly related, but it's very important, relative to Public Health Trust Fund, that dovetails into one of the factors that, in my view, was very important in selecting the team from UMass Amherst, and that is the Public Health Trust Fund really is, in my estimation, to be combined and used for not just research, but addressing and funding programs, because that's ultimately what
Right.
really prevents, helps, treats people who need it. Of course, you need to do the research first, and there's a little bit of a, expenditures that we have to do, perhaps of large magnitude, clearly, in the upfront, in our case. But at some point, we should figure out just what that mix may be. And this would be extremely helpful, in my view, with the input of the Gaming Policy Advisory Committee. What that mix between research and treatment should be. I don't know what that is, but of course we'll we'll figure that out. But the part that I thought was an important aspect that was very positive from the community level as the unit of analysis was that, in my view, that really informs programs. That could really inform the likes of our partner, the Mass Council on Compulsive Gambling, how to market, what languages to use when they market, where to put advisories, and any other plethora of treatment that goes along with the work that they do, which we will also fund and have the ability and mandate to do. Perhaps we do this today, in the next few months, a little bit heavy on the research, but that's the nature of what we have to do. The mix will change as time progresses. Now, that's not to say that we will stop doing research. There's an ongoing research annual agenda as it's mandated in the legislation. But I did want to mention that about programs, which is, in my opinion, the very important piece.
Yeah. Well, all right. And I think we all agree with that, and can't lose sight of it as we move down the road. So suppose I make this motion, which is that the Gaming Commission authorize Commissioner Zuniga to begin the process of refining the scope of work and undertake contract negotiations for the research project with the team comprised of UMass Amherst et al. As part of their response to RFR number MGC-research-2012, dated January 7, 2013, and bring the fruits of those negotiations, plus a cash flow analysis back to the commission for final approval.
Second.
Discussion? All in favor?
Aye.
Great. This is going to be very, very exciting. I think
Thank you.
Thank you.
we look forward to having a really world-class study come out of this. It'd be great. All right.
One more step, please.
There is one thing I overlooked when we were doing the regulation update and schedule, 6B, and that is that Commissioner Stebbins and I have been talking to various people, and are going to continue talking to various people about the team we need to assemble in order to process the application when they get here. And this is actually what made me think of the cash flow piece, because it's becoming clear that we ought to have components of that team in place soon so that they can help us in fact create the application and make sure that we have a structure that permits easy comparison of apples to apples. And I think we're coalesced around the notion that we need two key components and could get to work designing an RFR to look for those. Commissioner Stebbins, do you want to say anything about that?
Sure. I think even though we have 4 kind of evaluation criteria measurements, I think 2 of those criteria, the building and facility itself of the resort destination casino, as well as the financials, seem to lend themselves immediately to being able to identify the experts that will be helpful in reviewing, actually doing, as Mr. Chair, as you just mentioned, helping us in 2 critical steps from the conversations that we've had. One is having input into the application itself, the appropriate terminology, the appropriate information that needs to be collected and how it's identified so that we are comparing as best we can apples to apples and not apples to mangoes. And with some input from our friends at AIA looking at folks who can help us evaluate the project, the construction, the facility itself. So they have just sent me over, they reviewed our evaluation criteria. They pulled together lists of not necessarily individuals, but the types of professional consultants or help we should go out and identify. And again, on the financial piece, the first criteria, going out and looking for a firm that probably has great experience analyzing mergers, acquisitions, to really look thoughtfully through financials and pro formas and estimates relative to financing. So what I'd like to prepare is some framework to the RFP for those types of services and share that back with you as quickly as I can.
I think that would be good. That would be great. I think we really need to move on that, and I don't know that well, yes, I think that sounds like a good plan.
Can I highlight just one thing? We and I know you're talking about the scope of work, but we have a good framework of our RFPs, like the one that our team responded to. There's good templates that we can use. We need to think about the scope of work piece clearly.
We do need to think about the scope of the work, but then, as you say, we don't have to reinvent the wheel for what the RFP looks like. And it may be that there's some on the state contract. It may be that we can do some ISAs. There's a lot of ways, but we need to. So how can we best do that and begin to put some kind of a time frame around it? We're going to continue, you and I, to talk to people, to look at the ways they process things. But this can be going on in the interim, and it ought to go on in the interim.
Let me highlight something that that I experienced when I was writing the RFP for the research agenda. We knew that there was we wanted to do a lot of social analysis as we were mandated. There's a lot of problem gambling, addiction, etc. But we also read the economic impacts, and we wondered before we received the responses whether people would be interested in responding to a particular piece of the research agenda or maybe a comprehensive piece. We wrestled with the notion of whether we needed a program manager or whether that role the commission would play. And the analogy that I'm trying to say is we ended up on something that was broad, and the teams read that, got together and put together proposals. So in my estimation, if we decided on a discipline like all things finance and accounting, let's say, kept the scope of work broad, having to do with real estate, gaming, mergers, acquisitions, etc. Firms will hopefully read this and say, we could put together a multidisciplinary team, or we could help you with this one piece, or these 2 or 3 pieces, and just see what we get. As we that's just perhaps I'm stating the obvious. It worked really well on this case, and we could see what happens.
Well, let's talk further. That sounds like a good approach. Another approach might be to take what outcomes we're looking for and say who can deliver, and put those outcomes in an RFP. We need somebody who will assist us in doing X, Y, Z, and it could be one person or a team. So we can talk further about that. But how can we? What's a realistic way to put some target dates on that? Should we just do that administratively? Should we do that now? What does everybody think about that? because we need to, we've got so many things going, and we really, this is an important piece of the next step.
Right. Whether we're calling it scope of work or outcomes, in many sense, it's sort of the same. That's something that we just have to sit down and write. Whoever wants to or is taking the lead, I could take the lead on the finance piece if that fits everybody,
Okay.
or suits everybody,
Yeah.
or continue with the way we've been doing. Just
Okay.
thinking out loud.
Let's just put this on the agenda for next week and think in the interim about having something tangible somehow next week, even if it's an outline that we can work on, and bring back some kind of an outline so that we can begin to think about this and move forward.
I think there's also, as part of that, there's going to be, as we're going out and looking for these specialties, I think there's also going to be some kind of cross-criteria through each RFP about what we're looking for that respondent to agree to.
Right.
And those are pretty broad, but those will be consistent across those RFPs.
Right. And I think the trick is going to be to try to be broad enough yet precise enough so that we can get some quick responses from quality people. And so that's the target. Okay, so let's look at that next week. Before we close, let me simply say for our mutual benefit and for the benefit of others who are looking, that next week's meeting is starting at 9 o'clock. We have a number of topics on the agenda. So we're going to start at 9 o'clock as opposed to the 1 o'clock issue. We have some racing issues that we're going to discuss that Director Durenberg gave us a preview of. We have some scheduling things we're going to try to tighten down as much as we can. We're going to return to the Region C discussion and perhaps come to a conclusion, perhaps not. In that regard, I noticed today that I received today a letter from Todd and Weld that apparently was simultaneous, actually not simultaneously, released to the press before we received it. And in that letter, the firm stated that the commission had no power and no authority to open Region C to commercial gaming until it concluded that the Bureau of Indian Affairs would not take land into trust. The commission has never taken a position on that. That's one of the things the commission has to think about. The commission does have, and when last addressed this issue, does have a memorandum in its packet. It's been publicly distributed, in which, that I wrote, in which I took a distinctly different view of that and believed that, and stated that I believe that the commission's powers were not limited in that fashion, both because of the plain language of the statute and because of the absence of language that specified that. But that's just the view of one commissioner, and we have not adopted that view. We have not come to any coalescence around that. So Regency discussion is on the agenda for next week, and we'll take it as far as we can and make whatever decisions we're able to take. And then there are several other features of the discussion that we'll have next week as well. So that's why we're starting at 9 o'clock. Any other thoughts or considerations anybody wants to address? All right, then I'd entertain a motion to adjourn.
So moved.
Second?
Second.
All in favor?
Right.
Aye.
We're adjourned.